Good morning to you, friends. Here are some facts about the need, necessity, structure, forms, and different types of legal frameworks of autonomous bodies, and also the nature of specific services that are entrusted to autonomous bodies. And when I tell you about this, I have at the back of my mind some important organizations like the CAG's office, that is AG's office Bangalore, Aeronautical Development Agency ADA Bangalore. Similarly, DIAT, the Defence Institute of Advanced Technologies Pune, which I served before my retirement, and also the State Council for Science and Technology Karnataka, IIT Dharwad, and other organizations where I worked after my superannuation retirement. See, autonomous bodies are the organizations established by the government to perform and execute certain specific public services or to execute the government policies. And they operate outside the usual government departments, allowing a greater administrative, financial and operational flexibility, while they are funded fully or partially through the government grants. So in other words, autonomous bodies are set up only when some amount of independence and flexibility without a day-to-day interference of the governmental machinery is felt essential to discharge the functions entrusted to them. See, these organizations require autonomy. So the organization generally requiring autonomy are basically the educational institutions like the universities, IITs, IIMs, All India Institute of Medical Sciences, AIIMS, etc. They require the academic and administrative autonomy to shape their own curriculum and to conduct the research. Similarly, the research and development entities, the scientific, agricultural and the socio-economic research organizations, they also require independent research protocols. Therefore, they require autonomy. And into this category falls our Aeronautical Development Agency also. And also the regulatory and advisory bodies which are entrusted with the responsibility of setting the industry standards, conducting examinations or providing the specialized guidance to the government. They also require autonomy. And the promotional and the commercial bodies which are designed to boost the micro and small enterprises. The commercial bodies which are designed to boost the export-import management. They also require autonomy. And the cultural and heritage organizations which are set up to preserve our art, the historical documents and cultural heritage, the various academies of art and literature, etc., etc., they also require some amount of autonomy to discharge their duties. Then, whether all autonomous bodies of the central government are registered under Societies Registration Act. Whether it is mandatory to register them under the Societies Registration Act. The answer is no. Not all autonomous bodies should be registered under the Societies Registration Act 1860, although at present there are more than 150 autonomous bodies registered under Societies Registration Act 1860. And others, they are all established as statutory bodies or through different legal frameworks. See, an autonomous body in India can be established through several legal routes, depending on its intended purpose, powers, and the degree of independence required for executing the objectives of the organization. And the broad categories of the autonomous bodies are, number one, the constitutional bodies, that are the autonomous and created directly under the provisions of the Constitution. And category 2, the autonomous bodies which are statutory bodies created through specific parliamentary acts And number 3, other autonomous bodies created under the executive powers of the cabinet or the ministry of the government, like the societies, companies, trusts, etc. So now let us go into the details. Coming to the first category, namely the constitutional bodies. The constitutional bodies that are autonomous and created directly under the provisions of the Constitution are highly independent as their powers, duties and the appointment processes etc. are derived from the Constitution and they are secured by the constitutional provisions. So the autonomous bodies established under the provisions of direct provisions of the Constitution are the Election Commission of India under Article 324, similarly the UPSC created under the provisions of Article 315, the CNDG of India established under created the office of the CNDG established under the provisions of Article 148, the Finance Commission under Article 280, which makes recommendations on the distribution of the financial resources between the Union and the state. Similarly, the National Commission for Scheduled Castes created under Article 338, the National Commission for Scheduled Tribes created under the provisions of Article 338A, the National Commission for Backward Classes created under the provisions of Article 338B, etc., etc. And coming to the second category, the autonomous bodies or the autonomous entities falling under this category are the statutory bodies. See, these are created by specific acts of Parliament or the state legislatures. In their day-to-day administrative parlance, these statutory bodies have the statutory authority to make the regulations and manage the specific sectors. And the examples for the statutory bodies are, for example, the Reserve Bank of India, the Telecom Regulatory Authority of India, the University Grants Commission, the IITs and the AIIMS, the National Cooperative Development Corporation, the National Human Rights Commission, the National Green Tribunal, etc., etc. So the statutory bodies, which are, these are all the statutory bodies which are autonomous and which are independent and quasi-judicial. So they are the quasi-judicial autonomous bodies. They have quasi-judicial powers also. They are governed strictly by the provisions of their own parent act passed by the Parliament for its creation. So their functions, powers and the rules, they are defined directly within the governing legislation, within the governing act passed by the Parliament. So any change to the provisions of these statutory bodies, whether it is with regard to appointments or funding or the other activities, it requires amendment to the act by the Parliament only. And let us see the third category, namely the non-statutory and non-constitutional autonomous bodies. See, these are the executive bodies like the societies registered under Societies Registration Act 1860, the companies registered under the Companies Act incorporated as Section 8 companies, that is non-profit companies under the Companies Act 2013. Similarly, the autonomous bodies can take the shape of trust. So the trusts registered under Trust Act 1882 of India, etc., etc., fall under this category. So these bodies, they are established by a simple resolution of the union, means the government, the union government or the state government as the case may be. So a simple resolution of the union cabinet or the administrative, through the administrative orders of a ministry, it comes into existence. So under their executive powers, Like that, under Article 73 of the Constitution, these bodies are created rather than by a specific law. That is, you are not passing a law or passing an act in the Parliament for creating these non-statutory and non-constitutional autonomous bodies. So activities of these bodies, they are approved by their respective administrative ministry and not by the Parliament. Like in the case of statutory bodies, it need not have the approval of the Parliament. So coming to registered societies falling under this category, many research labs, councils and welfare boards are registered as societies under the Societies Registration Act 1860. They are run by the governing bodies, the governing councils that include the government officials but retain functional autonomy. So the societies registered under Societies Registration Act 1860, they are administered according to their own rules and bylaws, administered by their own governing council. They are administered by their own rules and bylaws. Rules and bylaws framed by the same body. So the rules and bylaws are laid down by their own governing body, and it can be changed by their own governing body or the governing council or general body, by whatever name you call. And because of this operational flexibility, the organizations choose to become the societies under Societies Registration Act 1860. And these specific bodies, they are required to comply with the 1860 Act or the relevant State Societies Act. And these registered societies, the so-called autonomous bodies, they lack the legal authority to enact the regulations. They lack the authority to levy statutory fee. They lack the authority to enforce judicial powers. So if an autonomous body needs a regulatory teeth, it must be formed as a statutory body. The Societies Registration Act 1860 primarily applies to the non-profit entities dedicated to charity, science, research and development, literature, etc., etc. And commercial, industrial or heavily regulated governmental operations, it demands, it requires the alternative structures like the public sector undertakings or the statutory corporations. So once again, I would like to repeat here that the statutory bodies are directly accountable to the Parliament, whereas societies are accountable to their governing council or governing body and to their parent ministry. Meaning, even the reports of the societies that are referred to the governing body and the respective ministry for approval, it requires the approval of only the governing body and the respective ministry and not the Parliament, where it is referred or placed before the Parliament as per bylaws of the society. It is only for their information and not for approval. See, the constitutional, coming to the constitutional rights under Article 19(1) of the Constitution of India, citizens have the fundamental right to form associations. The central legislation under the 1860 Act, it does not impose compulsory registration for all associations unless specified by the state specific amendments. But it has a provision for the registration of private associations also, and that is how Areva is also registered as a society. Thank you, friends.